why he separated thousands of children from their families, and I hope he asks him why the Department of Justice under the Trump administration undermined the civil liberties of so many people across the country with these secrecy orders. I wanted to pick up on, I believe it was Mr. Cicilline's questions about what is needed to get these protection orders. I think that this whole process is really quite stunning for most Americans who don't distinguish between what happens to their data that's stored and what would happen if they were to be in their home and their files were to be seized. And so I want to just read from, this is a U.S. Department of Justice Office of the Deputy Attorney General memo from October 19th, 2017. And in the footnote, it says, when applying for a 2705B order to accompany a subpoena seeking basic subscriber information in an ongoing investigation that is not public or known to the subject of the investigation, stating the reasons for protection from disclosure under 2705B usually will suffice. And it actually just puts a point on, I think every one of you in some way or another has commented on this. I think Mr. Turley, you were speaking to this as well. It's quite stunning to me that there really seems to be no standard at all. So of course the courts are not going to get any information because the direction is you don't need to provide it. And so I'm wondering, on a scale of 1 to 10, of 1 being a rubber stamp and 10 being a real process that protects our civil liberties, our rights, just curious where you would put the current standard, and we can just go through quickly, Mr. Turley.
I put it at a 1, and I really compliment you for highlighting that footnote because it is how it reads. It's basically telling prosecutors, confine what you say. You don't have to give any details. And the Department of Justice benefits from that, right? If you can use boilerplate and use it over and over again, then judges, when they see it, basically say this is all they have to show. And that's how you get to these high numbers in terms of the use of these devices.
Mr. Burt?
Yeah, I would agree that it's a 1, and while there's that footnote, that same policy, which is the one that emanated from our litigation against the department, says that they're supposed to articulate facts. But then when you look at the template that the Department of Justice provides to the 93 offices around the country that says, here's how to get these secrecy orders, it says, just write down this boilerplate. So the actual form template is consistent with the footnote, and there's really no meaningful process.
Ms. Oberlander?
I mean, I don't have a lot of exposure to these, only the ones that have been reported, but certainly for the ones that have been reported, 1 or 2, it's pretty low.
Ms. Burton?
I put it at a 0.
Yeah.
I mean, this falls into the category of a ham sandwich can be indicted. This falls into, the government calls the shots, and that's the end of the discussion. That goes to a 0 to me.
I object. I wasn't given that option when I took the test. But
You stuck to the instructions. Now, let's say, Ms. Burton, I'll just stick with you on this one. Let's say that the extension is obtained, and then the very next day, the case is dropped because there's not enough, there's not enough evidence, whatever. What happens to the extension? Does the DOJ go back and say, oh, actually, we don't need that extension anymore? Can you give us some knowledge about that?
Yeah, I mean, we have a case where, 15 years ago, very, very beginning of cloud computing, it is still a sealed proceeding. I mentioned it in my testimony. So I think this is a critical problem. You've got to have a sunset provision at the very least. But, again, if you have Pentagon paper type standards before you can even enter into this kind of a secrecy order, you aren't going to have a big problem. I mean, national security and secrecy orders are a very small percentage of what we're talking about.
Right.
So I think you would have a sunset and a small problem.
So, Mr. Burt, I was struck by the data of Microsoft receiving 5,500 requests just in the first half of 2020, and your company turning over basic data to 54% of the requests. Compare that to the New York Times reporting that Apple turned over basic data in 43%, Google turned it over in 83%, Facebook turned it over in between 85 and 89%. And it seems to me that we are essentially depending on tech companies in this case to negotiate the civil rights and civil liberties of their users. Why is it that your rates, and if Apple were here, I would ask them as well, were so much lower? It seems to me you take this very seriously in how you move forward with these requests.
Time of the gentlelady has expired. The witness may answer the question.
Yes, well, we do take it very seriously because we think it is our obligation to protect our customer interests here. And because we do believe this is a First Amendment violation, a restriction on our ability to inform our customers when the data they trust us to hold securely for them has been taken by the government. But somewhat in defense of some of my competitive companies, you also have to understand that different companies have different categories of data. And so we have a lot of what has been referred to as metadata. And often what we get is a subpoena for that metadata, then accompanied with a privacy or a gag order. And so our percentage about how often we provide content versus metadata is in part a reflection of the volume of accounts where we do have metadata, whereas a social media company, for example, that metadata might be less interesting to the government. They might be more interested in the content of the postings. I don't know because I don't represent them and I don't see the demands that they get, but there are possible explanations other than just how seriously we do take our obligation.
Well, thank you for taking it seriously. I yield back, Mr. Chairman.
Gentlelady yields back. Ms. Scanlon.
Thank you, Mr. Chairman, and thank you to all of our witnesses for speaking today about these really important issues.